Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a criminal case. We handle criminal cases in this court. The criminal case that you have is classified as a misdemeanor. Criminal cases are classified as felonies and misdemeanors. Your felony cases are referred to as your most serious type of offenses, whereas your misdemeanors are referred to as your more petty offenses. Just because it's referred to as petty does not mean that they are not serious. Now, if you had a felony offense, as I mentioned earlier, your felony offenses are divided into 5 categories. And we'll start at the top and work our way on down to the bottom. You have a capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If you're convicted of a state jail felony, your punishment range is minimum 6 months to maximum 2 years in the state jail and a fine up to $10,000. If you're convicted of a third-degree felony, range of punishment minimum 2 years to a maximum of 10 years in the state penitentiary and a fine up to $10,000. If you're convicted of a second-degree felony, range of punishment minimum 2 years to a maximum of 20 years in the state penitentiary and a fine up to $10,000. If you're convicted of a first-degree felony, range of punishment is a minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine up to $10,000. Now, if you're convicted of a capital murder, range of punishment is death. Well, the range of punishment is life without the possibility of parole or death by lethal injection. You don't have to worry about those offenses because your case, as I mentioned earlier, is a misdemeanor case. Now, misdemeanors are divided into 3 categories, and we'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. If you're convicted of a Class C misdemeanor, the range of punishment is by fine only. Now, those Class C misdemeanors are cases that are appealed up to this court from the JP court or from the city court. And the range of punishment is still the same, meaning that it's by fine only. Normally, the fine does not exceed $500. If you're convicted of a Class B misdemeanor, the range of punishment, minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, or a fine from $0 to $2,000, or you could be given both such fine and confinement. If you're convicted of a Class A misdemeanor, the range of punishment, minimum 0 days to a maximum of 365 days in the county jail, which is a year, or a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, if you are eligible for probation, there are 2 types of probation. One type of probation is referred to as unadjudicated probation, which means that you will not have a conviction on your record. And if you successfully complete that probation, you may qualify for what we call a non-disclosure. The other type of probation is regular probation or adjudicated probation. With that type of probation, it will result in a conviction on your record. However, there's something that is called judicial clemency. Judicial clemency means that the court or the judge can set aside the conviction. And the way that works is, in order to be eligible, you have to first essentially complete the probation. They cannot have any more time left on the probation, and you have to be successfully discharged off the probation. Once those three things happen, then the court can set aside the conviction. And if your conviction is set aside, if you get a subsequent offense, meaning that if you get a conviction later on, the case can be brought back up, revived, resurrected, and used against you. If you try to get a license with CPS, then they could either deny giving you a license, or if you have a license, they can suspend or revoke the license that you have with CPS. Now, The paperwork that you have on the clipboard talks about one of the rights that you have as a defendant in a criminal case. And one of the rights that you have is you have a right to have a lawyer to represent you. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Now, as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset. Reset means you'll be given another court date to give you time to hire an attorney. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire. Now, the financial questionnaire should be the third document on the clipboard, and that document is titled Jefferson County Affidavit of Indigence. You'd have to fill out everything on the first page, and then 2/3 of the second page, the bottom part where it says defendant eligibility meets the eligibility requirements. Well, defendant currently meets the eligibility requirement. You don't have to fill that portion out because the court will fill that portion out. Now, so you would have to fill out that financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case. Now, unless you first sign a written waiver of your right to be represented by an attorney. Now, the written waiver should be the second document on the clipboard. That's for individuals who will be waiving their right for an attorney or giving up their right to have an attorney to represent them, and that they're desiring to represent themselves. Then they would have to read and sign that document. And that document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And then once you sign that document, you'll be able to represent yourself, and you'll be able to talk to one of the two prosecutors in court that's sitting at the table before you. You can talk to them about your case to see if something can be worked out. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, that is, if you decide to represent yourself, you may change your mind at any point. And if you decide to change your mind, you can ask that an attorney be appointed to represent you. Now, at the bottom of that document, in bold letters, is titled, or it states, defendant's choice, mark initials next to only one choice. If your choice is to represent yourself, or the first statement says, if you want to reset your case, that is, if you want to hire an attorney to represent you, then you'll put your initials on the first line to the left. If you have already hired an attorney to represent you, then you put your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you've already been appointed a court-appointed attorney to represent you in this case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney, that is, give up your right to have an attorney and represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name at the bottom of the document on the line that is titled defendant, and you will date it today's date, November 28th of 2023, on the line that is titled date. Now, as a defendant in a criminal case, you have a right to have a trial by jury. For those young people that are sitting in an area over there, we call that the jury box. That is, 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence, listen to all of the arguments of the lawyers. They will deliberate and they will decide whether to find you not guilty or guilty of your charges. You also have a right to waive your right to have a jury trial, which means you have a right to give up your right to have a jury trial. Now, if you waive or give up your right to have a jury trial, your case will come before the court, before the judge, in one of three ways. One way it can come before the judge is by way of a bench trial. A bench trial is a trial by judge only. And that just simply means that you'll have a trial, the judge will listen to all of the evidence and the arguments, and then the judge will decide to find you not guilty or guilty of your charge. The other way that your case will come before the judge is by way of an unagreed plea bargain agreement. What that basically means, you and the state have not been able to work out a plea bargain agreement, and you want the judge to decide what your punishment will be. We call that an unagreed plea bargain agreement. And the third way your case will come before the judge is by way of an agreed plea bargain agreement. That means that you and the state have reached an agreement to settle your case, and you want, and then your case will come before the court. The judge could either accept or reject your plea bargain. Now, if the judge accepts your plea bargain agreement, and if you decide that you want to appeal your case, then you have to get permission from the judge to appeal your case. And if the judge gives you permission, then your case will go up to the Ninth Court of Appeals, which is right above us on the third floor. They will review your case to see whether or not this court committed an error by convicting you, whether or not you were wrongfully or whether or not you were wrongfully convicted. Now, if they grant your appeal, then they can just simply find you not guilty. Or they could send the case back down to this court and order this court to give you a whole new trial. If they reject or deny your appeal, then you can appeal it to another court, to a higher court than the Ninth Court of Appeals. You can appeal it to the Texas Court of Criminal Appeals, which is located in Austin, Texas. It is the highest criminal court in the state of Texas. Now, you would have to file what is called a pro se petition for discretionary review. Pro se means that you'll be representing yourself. In essence, you will not have an attorney to assist you. You'll be representing yourself. You'll be filing this petition to the Court of Criminal Appeals, asking them to review your case to see whether or not your appeal should have been granted, whether or not this court committed an error by convicting you, or whether or not you were wrongfully convicted. Now, if the Court of Criminal Appeals grant your pro se petition for discretionary review, they could just simply find you not guilty, or they could send the case back to the Ninth Court of Appeals, or they could send it back to this court and order this court to give you a whole new trial. If they deny your petition for discretionary review, at that point, your conviction will stand. Now, the other way that your case can come before the court, as I mentioned earlier, is by way of an unagreed plea bargain. Now, if the judge on the agreed plea bargain, if the judge rejected the plea bargain agreement, as I mentioned earlier, then at that point, you can withdraw, which means you can take back your plea. In essence, if you and the state, let's say you and the state worked out a plea bargain agreement, and the state says, well, Judge, our plea bargain agreement is for the person to, let's say, pay a fine. And the court say, well, the court rejects that plea bargain. Then you can say, well, Judge, I withdraw, or I take back my plea. Okay? Now, the other right that you have, I mentioned earlier, you have a right to have a trial by jury or You can have a bench trial, or you can have a plea bargaining agreement or unagreed plea bargaining agreement. The other right that you have a right to have witnesses to come to court. That chair that I'm pointing at that have the microphone in front of it is called a witness stand. And what witnesses do, they can come to court and testify for you, or they can testify against you. Now, as I mentioned earlier, you have a right to call witnesses to testify in your case. Now, you also have a right to waive your right to call witnesses. What that basically means is you have a right not to call any witnesses in your case. And if you do not call any witnesses, or you waive your right to call witnesses, that does not mean that the state will not be calling witnesses in your case, because the state will be calling witnesses in your case. And the other right that you have, if you have an attorney, your attorney can ask you witnesses questions, or if you represent yourself, you can ask the witness questions. We call that either direct examination or cross-examination. You also have a Fifth Amendment right against self-incrimination. That simply means you have a right not to testify. The state of Texas, the government cannot force you to take the witness stand if you invoke your Fifth Amendment right against self-incrimination. That is, you have a right to remain silent. Now, you can waive or give up your Fifth Amendment right against self-incrimination. And if you waive or give up your Fifth Amendment right against self-incrimination, that simply means that you will be testifying in your case. Now, the other right that you have is you have a right to have what is called discovery. Discovery means you have a right to see the evidence that the state has, or that the state will be using against you. That is, you have a right to see documents, witness statements, your statements, police reports, lab reports, if they have any photos, videos, audio recordings, any type of instruments, any evidence that the state will be using, you have a right to have access to that evidence. That's what is called discovery. Now, you also have a right to waive or give up your right to have discovery, which means you have a right not to have access to the evidence that the state will be using against you. Now, everyone that's here today has been, you've been arrested on your case and you're out of jail. Either you're out on what is called a cash bond, which means that you paid the full amount of the bond to get out of jail, or you're out on a surety bond, which means that you paid a percentage of the cash bond to a bondsman. In essence, you might have paid 10% of that bond to the bondsman to get out of jail, or you're out of jail on what we call a PR bond, or personal recognizance bond, which means that you have not paid any money to get out of jail. You were released under your own personal recognizance with a promise to appear here in court. Now, every day that you spent in jail, that jail time could be used as credit towards your punishment. So, for example, if you spent 5 days in jail and you and the state has reached an agreement for you to serve 5 days in jail, you would not have to serve any more time in jail, because the 5 days that you spent in jail, you'll be given credit for that time. Therefore, you'll be given credit for time served. Every day that you spent in jail can also be used as time toward your fine and court costs. So, for example, every day that you spent in jail, $100 will be credited toward your fine and court costs. So if you spent 5 days in jail, that's $500. If the state is offering you fine and court costs of $500, you spent 5 days in jail, that means you won't have to pay anything, because the time that you spent in jail has already paid it off. Therefore, your fine and court costs will be taxed and retired. Now, if the state is offering 7 days in jail and you spent 5, that means you would have to serve 2 days in jail. Or if the state is offering $700 fine and you spent 5 days in jail, which is $500, that means you'd have to pay $200. Now, if you cannot pay the $200 on the day that your case is disposed of, then we can put you on what is called a payment plan, where you can pay out your fine and court costs in monthly installments. Now, if you cannot pay off your fine and court costs in monthly installments, we can convert the fine and court costs to community service, which means that you can work off your fine and court costs. You will receive $12.50 that will go towards your fine and court costs for every 1 hour of work that you do. So if you work 8 hours, that's $100 that will go towards your fine and court costs. Now, Jefferson County has a program for first-time offenders. If you've never been in trouble before, there's a program that is called pretrial diversion. That program is run through the district attorney's office. And with the pretrial diversion program, they will dismiss your case and you can get it expunged from your record. Expunged means erased, deleted, or wiped off from your criminal record. And in order to get into the program, in order to be eligible for the program, it has to be your first time getting in trouble. Cannot be in for an offense involving unlawful carrying a weapon or resisting arrest. And you have to have an attorney to assist you with making the application to get into the program. And as I mentioned earlier, if you get into the program cases and you complete the program, cases dismissed, you can get it wiped off your record. We call that expunged. Now, if you are a veteran of any one of the branches of the United States military, any one of the branches of the United States military, Jefferson County DA's office also has a program that is called Veterans Court. Veterans Court is a program for veterans only. And with that program, if you get into the program and complete the program, your case is dismissed and you can get what is called a non-disclosure. A non-disclosure means that we can't disclose the fact that you were on in the Veterans Court program for this case. It will be what we call sealed to the general public. Now, the government can have access, but the general public cannot have access, which is most of society is the general public. Now, if you're interested in any one of those programs, just let us know. We have, we'll be able to point you into the right direction, to the right people to talk to so that you can get into that program. We also have a program, this court has a program that is called the Community Safety Initiative. It is a program, the CSI program is Community Safety Initiative program that I started within 100 days of taking office in March of 2017. That program is designed to address the issue of what we call recidivism. Recidivism means where people commit crimes over and over. And so we address this issue of recidivism through our community safety initiative or the CSI program. We're in that program. We have partnerships with local agencies. One of the agencies that we have a partnership with is Spindletop Center. Spindletop Center is our local mental health authority here in Southeast Texas. And with that program, Spindletop is able to address individuals who have issues with anxiety, depression, or any host of any other mental illnesses. Now, what they will do, well, to participate in the program, you don't have to be insane or incompetent to participate in the program. You can just merely have anxiety. That's sufficient. Depression or whatever. Any one of a host of those programs, you'll be qualified. And with that program, they will be able to do what is called a private interview, an assessment, and they can develop a treatment plan, either outpatient, inpatient, depending on your mental health needs. If you have issues with drugs or alcohol, then Spindletop has a program that is called ATAR, and our local Drug and Alcohol Council has a program that is called OZAR. Both of those programs are designed whereas they will be able to do a private screening, an assessment, and you can refer to treatment for either outpatient or inpatient treatment, depending on your drug or alcohol issues. If you do not have a job, or if you're looking for a better job, we have a partnership, the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in any one of those areas, then they will assist you at getting a job in the area that you're trained in. Now, if you have not graduated from high school and you would like to get your GED, CICE has a program for graduate equivalency diplomas. You can get your GED and in the CICE program. Now, all of these programs that I just mentioned do not cost you anything. They are free. Only thing it does cost you is just a little of your time to participate in the program. Now, in this court, we do not just give time, we take our time. And we believe that we do not just arrest the problem, we address the problem. We believe that if we address the problem, we can produce productive people. And if we produce productive people, we believe that productive people will not commit crimes because they have too much to lose. And so I like to say this is that when you come to county court at law number 2, we do not have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before the court. And we're trying to make a difference. If we make a difference in the lives of the individuals that comes before this court, we'll make a difference in their home. And if we make a difference in their home, then we'll make a difference in the community, because what comes out of the home goes into the community. And so with this program, we believe that we can address the issue of recidivism. We believe that we can make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and to raise our families. And so if you're interested in this program, we have brochures that we can give to you so that you can speak to the right people to help you to get into the program. Now, earlier, I pointed out to you there was some young people sitting in the jury box. They are from the Spindletop Center, and they're going to come to you right now and tell you a little bit about the program that Spindletop has to offer. We have Deputy Hinton and Gabby. Will y'all come forward?
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission by the sheriff's department. I am here with my coworker Gabby. Now, Gabby is a qualified mental health professional. The reason we are both here this morning is that the judge cares about every single person that comes before the bench. The judge has found, and statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources that help you in your particular situation.
And so we can understand being in court doesn't help any of your life situations. It actually kind of increases that stress. We can understand that it will increase stress on maybe the bill you have, your job, education, or just anything important you have now. We know that it doesn't help being in here, so that's why we want to see what we can do to help you as best as we can.
Maybe this is your first time to be here, for some, maybe it's your 10th time to be here, there's still hope. What we're offering you today is the ability to change your life, but we're gonna need something from you. We're gonna need you to share that need with us. And Gabby's gonna tell you how to actually do that very privately, so we don't embarrass anyone.
So I can have an extra form. That's okay. The form that you have right there is HIPAA, basically provide my HIPAA, means it's not shared with anybody else except for me. I'm the only one who's gonna put these papers back. I'm the only one who's gonna have the phone number on there, which is another really important piece. In order to contact y'all, I need a good phone number for y'all, and the method that I'll do is I'll send out an initial text, because I know you're busy throughout the day. I don't want to interrupt your work schedule or your school schedule. So I'll send out an initial text. If your phone doesn't receive text messages or even a home phone number, please let me know, or put like a little note on the side so I know that I can call. The paper that I have that you have right there, it only allows me to contact you once. After, if you don't want to be contacted again, you don't have to answer, or you can just tell me things are good. I will not pull up your phone. It won't be any robocalls. It will be from my work. And so on that paper, please put your phone number for me. And also, if you want to talk privately today, or if you have any questions for me, please let me know. You can check on the very bottom of that. You can check on there if you want to talk with me. And there's gonna be a checkbox up there. The other really important thing is if you're in need of any resources, it's gonna ask you on, I believe, the third line down. Just check any resources that you need, and I can get with you to see what we can do and what resources we can provide that's for you.
Before you leave here today, I also want to give you this flyer. On the back of it, it tells you a little bit about the advantages of participating. But I don't think I have the 1-800 number on there. Should you ever find yourself in an unsafe place, you can call that number. You You can also call that number if you do not want to wait on her text, and you can get help immediately through that as well. Now, just shortly, the court is going to go into recess, and when it does, we'll be coming out there, we'll pick up the forms from you, and I'll be handing this out to everyone as well. Thank you, Your Honor.
You're welcome. Now, ladies and gentlemen, the paperwork that you have on the clipboard, if you need any assistance at filling out that paperwork, we have our court personnel who's here who will be able to assist you at filling out the paperwork. Once the paperwork is filled out, we will pick the paperwork up, and then we have to go through it and evaluate it, make sure that everything is filled out properly. And then once that's done, then we will call you before the bench one at a time regarding your case. And then once you finish here at the bench, you'll go to your case will be probably reset, or you being put in a category. Well, if you represent yourself and you want to talk to the prosecutor, we'll allow you to do that. Or if you apply for a court-appointed attorney, we'll see whether or not you qualify or if you're eligible. And once we finish with your cases here today, you'll be free to go. But before we're able to do that, that's going to take a little time for us to do the things that I just mentioned. And so if you need to use the restroom, there are two restrooms right outside in the hall. The male restroom is in front of County Court at Law number 3, and the female restroom is on the opposite side of the hall in front of the 172nd District Court. Now, do not leave the courthouse, because if you leave the courthouse and your case is called and you're not here, your bond may be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest. So at this time, we're going to go into recess to give the folks from Spindletop an opportunity to visit with you, and also to have the court personnel to assist those individuals that need some assistance at filling out the paperwork. So at this time, the court will be in recess. Oh, Jefferson County Court at Law number 2 is back in session. The court is in session and calls number M331050. Case is styled the state of Texas versus Demetria Rochelle Hayward. Ms. Hayward, is that your full name?
Yes.
How you doing, Ms. Hayward? That's good. Now, Mr. Hayward, the state is represented in this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, Judge, and yourself?
I'm doing fine, thanks for asking. Now, Ms. Hayward, the state has mentioned that you and the state has come to an agreement to resolve your case, and the agreement which y'all had reached was that you were supposed to complete the anger management class, and then upon the completion of that class, then the case will be dismissed. Is that correct, Mr. Hubel?
Yeah, yes, Your Honor. And it appears that the course that the defendant has enrolled in is 12 total classes.
Right.
So at the completion of those 12 classes, the state will submit a dismissal.
Okay. Now, Ms. Hayward, you understand that? So it's my understanding that she did just about halfway
Yes, sir.
through? Okay. So what we're gonna do, how long does it usually take to do like one class? Is it like one a week or something? How does it work? 1 a week? Okay, so we're gonna reset this 60 days. So I'm just saying, in 8 weeks, you should have completed each one of the class. Oh, you got 5 more to go?
Yes,
Yes,
sir.
sir.
I gotta reset it for 6 weeks then.
Well, it's
The holidays.
Oh, I forgot
Okay,
about
yeah,
that. Okay, just do 8 weeks, okay.
It's January 23rd.
Okay, so we're gonna give you the January 23rd. The case is gonna be reset to January 23rd. Once you get your reset, you'll be free to go. And you have a blessed day. Oh, you're gonna stand over here and get your reset.
If I can make a copy of it,
Yeah.
I'll bring it right back.
Okay.
Okay, he's gonna make a copy of that. Yeah, sit right there. Jefferson County Code of Law number 2 is back in session. First case is cause number M333-958, case of South State of Texas versus Kenneth Clark. Clark, would you please stand in front of the bench? Right here. Mr. Clark, would you please raise your right hand? Mr. Clark, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
I do.
You may put your hand down. Now, Mr. Clark, I have before me 2 documents. Well, first of all, Mr. Clark, how are you doing?
I'm well. How are you?
I'm doing fine. Thanks for asking, Mr. Clark. I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled Defendant?
Yes.
Are these your initials on the line that state you'd like to waive your right to an attorney and represent yourself?
Yes.
I also have another document that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
And Mr. Clark, before you sign and initial these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Clark, just go back and have a seat. We'll have one of the prosecutors to come out and talk to you. Next case is cause number 23-CCCR 1446, case of Style of the State of Texas versus Octavia Herndon. Okay, your full name is Octavia Lynette Herndon. Herndon, would you please raise your right hand? Ms. Herndon, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing?
Good.
I'm doing fine. Thanks for asking. Ms. Herndon, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants While Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line state you'd like to waive your right to attorney
Yes,
and represent yourself? I also have another document that's titled Waiver of Counsel Purposes of Entering a Guilty Plea Proceedings Trial. You recognize this document?
yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Ms. Herndon, before you signed and initial these documents, did you read the documents?
Yes,
Did you understand what you read?
yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Herndon, just go back and have a seat, and one of the prosecutors will come out and talk to you. Next case is cause number 23, cause number 23-CCCR 1384. Case is Style of the State of Texas versus Carbon Raleigh. Mr. Raleigh, would you please raise your right hand? Mr. Raleigh, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Raleigh, you may put your hand down. Mr. Raleigh, your full name is Carbon Jade Haley?
Right.
Raleigh?
Yes, sir.
Okay, how are you doing, Mr. Raleigh?
I'm all right.
Okay, now, Mr. Raleigh, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes,
And is this your signature on the line that's titled Defendant?
yes,
And are these your initials on the line stating you want to waive your right to an attorney and to represent yourself?
yes, sir.
I also have another document here that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding in a Trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Raleigh, before you signed and initialed all of these documents that I just showed you, did you read the documents? And did you understand what you read? Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Raleigh, just have a seat and we'll have one of the prosecutors to come out and talk to you. You can bring these to the,
We don't need them.
you don't? Okay. Next case is cause number 23 CCCR 1578. Case is filed the state of Texas versus Craig Stephen Simmons. Mr. Simmons, your full name is Craig Stephen Simmons.
Yes, sir.
Mr. Simmons, would you please raise your right hand? Mr. Simmons, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Simmons, you may put your hand down. How you doing, Mr. Simmons?
Doing good.
That's good,
How
Mr.
are you?
I'm doing fine. Thanks for asking. Mr. Simmons, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Sir.
And is this your signature on the line as titled defendant?
Yes,
Are
sir.
these your initials on the line state you would like to apply for court-appointed attorney?
Sure.
Mr. Simmons, I also have before me a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that's titled defendant signature. Is this your signature?
Yes, sir.
Mr. Simmons, before you sign and initial all of these documents that I just showed you, did you read the documents? And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Simmons, based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Don Boudreaux. Attorney Boudreaux will be given information to contact you, and you will also be given information to contact them. Our court coordinator will give you that information. However, before she gives you that information, I need to give you some bond conditions. Ms. Mosby, could you hand these conditions to Mr. Simmons? Mr. Simmons, the bailiff has just handed you a document. The bailiff has just handed you a document that is titled Standard Bond Conditions. Do you see that title? It says Standard Bond Conditions in County Court at Law Number 2.
Yeah. Nothing. Yeah.
Now, I'm going to go over these conditions with you. And it reads as follows. Following the arrest and or accusation in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release for any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol anytime as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol. And the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply because that only applies in the DWI case. Your case is not a DWI case. Now, Mr. Simmons, if you violate any one of these conditions,
Yeah.
your bond can be forfeited, revoked. And if your bond is revoked, a warrant will be issued for your arrest, and you'll be arrested and placed in Jefferson County Jail. Do you understand that?
Yes, sir.
Okay, so Mr. Simmons, just have a seat in that first chair by the wall, and just go to the window right, second window.
Is this your next court date?
Yeah.
You said you contacted me, before you come in, I tried to do that, and I didn't know, your attorney, so this is an attorney. This is the contact information down here, thanks. Thank you.
Now, you're free to go. You're free to go.
Me?
Yes.
Thank you, sir.
July L. Mitchell. Is this jailer? How you pronounce your middle name? Anaya? Ms. Mitchell, would you please raise your right hand? Ms. Mitchell, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Ms. Mitchell? You doing good? That's good. And Ms. Mitchell, I have before me two documents. First document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document?
Yes.
And is this your signature on the line that's titled Defendant? And are the initials online to state you'd like to apply for a court-appointed attorney? I also have another document here that's titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Now, Ms. Mitchell, before you signed and initialed these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Mitchell, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Tom Burbank. Attorney Burbank will be given information to contact you. You will also be given information to contact him. Our court coordinator is going to give you that information. Once you get that information from the court coordinator, you'll be free to go and you have a blessed day. Please have a seat in that first chair by the wall. Charisma Kenyatta Sharesh Keys. Okay, okay. How you doing, Ms. Keys? I'm doing fine. Thanks for asking. Ms. Keys, would you please raise your right hand? Ms. Keys, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Keys, you may put your hand down. Now, Ms. Keys, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
Are these your initials on the line say you'd like to apply for court-appointed attorney?
Yes.
I also have another document here. This document is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Ms. Keys, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes,
And is everything in these documents true and correct to the best of your knowledge?
sir.
Okay, Ms. Keys, I read your answers. Based on your answers, meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Christy Cawthon. Attorney Cawthon will be given information to contact you. And you will also be given information to contact her. Our court coordinator is going to give you that information. And once you get the information from the court coordinator, you'll be free to go. And you have a blessed day. I think that West, oh, he's out there. Next case is cause number 23-CCCR 1988. Tracy Style, the state of Texas versus Wilfredo Commission.
I do need to move stuff. Is this lady? Oh. Good day.
Okay. This is cause number 23-CCCR 1988. Case is filed in the state of Texas versus Wilfredo Commission. Mr. Commission, is that your full name?
Yes, it is.
Okay, Mr. Commission, would you please raise your right hand? Mr. Commission, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How you doing, Mr. Commission?
I'm doing good. Thank you, sir.
That's good. Mr. Commission, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. And do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line state you'd like to apply for court-appointed attorney?
I have a little caveat. My pro bono was supposed to show up today and she didn't. And I would like to know if she may be the person that she went through the discovery phase with me through the legal discovery phase on the case. And I would like to know if she'd be able to continue being my pro bono attorney.
Or who is your lawyer?
She didn't show up today. She called in.
I didn't ask what is that. What's her name?
Laurie Perozzo.
Laura Perrazzo? Okay, so do we have a letter of rep? Yeah, that was rescinded. You don't have an attorney at this time.
Okay, so this is my fourth arraignment, so I'm just.
Your fourth arraignment. You've been here 4 times in this court?
No, not in this court, sir.
Okay,
What I'm saying is, I haven't been able to, make a plea of innocence yet, and I just wanted to have a representative, but this would be I have 3 Jefferson County arraignments, and this is the 4th one now, and I haven't been able to say, give a innocent plea.
okay, if this is your first time here, how have you had 3 previous arraignments? Because this is the arraignment.
Maybe I'm using the wrong term then, and when I was in the jail, they said they would call it an arraignment.
Yeah, but that's a different hearing.
Okay. So
Yeah, I think it's a
So in
15.
that arraignment, those 3 times, I never received any kind of representation for due justice in my case. And
Well, that should have, I don't know if you applied for a court-appointed attorney, they would have appointed an attorney to represent you. But you're here, before that was done, if you bond out, then your next court appearance will be this arraignment, and then you'll ask for your court-appointed attorney here.
yes, that's the way she explained it, and I didn't understand, and if I'm just going forward with
I mean, obviously, you entered a plea of not guilty, you asked for an attorney, and so that's why we're here.
yes.
Okay.
Okay, thank you for clarifying. You did
Okay.
a great job. I think it is very disturbing.
Okay.
Yeah.
Now, let me do this here. This document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled
Yes, it
Defendant?
is.
On this line, instead of initial saying that you'd like to apply for a court-appointed attorney.
Yes, sir.
Okay.
Yes, but Your
And-
Honor, I just wanted to know if Laurie Perozzo, if she kind of.
We going down the list.
Okay.
we have a
We
list.
gotta do a list, so they gotta be a new discovery
Well,
on the case.
you'll talk to your attorney,
Okay,
whoever your attorney is. Okay, you're gonna get an attorney.
okay.
Okay, now, this next document is titled Jefferson County Affidavit of Vengeance. Do you recognize this document?
Yes, Your Honor.
And on page 2 of this document, instead of it, there's a signature on a line that is titled Defender Signature. Is this your signature?
Yes, Your Honor, it is.
Now, Mr. Commission, before you signed and initialed these documents that I just showed you, did you read the documents?
I do.
And did you understand what you read? And I think you
I do
had,
now. I
Okay.
do now. I didn't when I was doing it.
okay,
but
now
I
you
do.
had some assistance that filling out these documents. Is that correct? You had our court, you talked to one of our
I-
court personnel?
Yeah, yep. So between the two understandings, I got a better understanding what I signed just now. Thank you.
Okay, so you understand everything in these documents that you just signed?
Yes, Your Honor.
Okay, now, and is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Okay, now, Mr. Commission, based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Giles Cole. And you're gonna be given information on how to contact Mr. Cole. Mr. Cole will also be given information on how to contact you. Our court coordinator is going to give you that information. Now, once you get that information from the court coordinator, you'll be free to go. Now, before you get that information, I need to give you some bond conditions. And Ms. Mosby, could you hand these bond conditions to Mr. Commission? Okay, now, Mr. Commission, the bailiff has just handed you a document that is titled Standard Bond Conditions and County Court at Law Number 2. Do you see that title?
Yes.
Okay, I'm going to go over these bond conditions with you. And it reads as follows. Following the arrest and or accusation in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. You understand that condition?
Yes, Your Honor. I'm not, yes, Your Honor. I'll leave it there. Thank you.
Or it just says you can't break the law while you're out on bond.
Yes, Your Honor.
Okay. The defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, I do, Your Honor, on that one. On the first one, I'm sorry to go back. I was just gonna say that this is still an accusation that I'm in, and that
It's not, it's just like, okay, it's not saying anything about that case, this case. It's saying that if you are out on bond,
Yeah,
and if you commit a crime,
yeah. I don't.
that's totally,
Okay.
that's a different
I get-
crime. If you commit a crime while you're out on bond, your bond may be revoked. Okay, which means you could be placed in jail for violating the conditions of your bond.
That's what they did this time to me.
Okay.
But I have my hearing, so I hear you. Thank you, Your Honor.
Okay, now, the defendant shall not communicate, that's number 3,
Yeah.
shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim.
Your
Do you
Honor,
understand
was
that?
my prior home though, and I have things in that address, so how do I get, like, say, any types of valuables or?
You can talk to your
Okay.
attorney, Mr. Cole, about that.
Okay.
I can't give you any legal
Okay,
advice.
okay, thank you, sir.
Okay? Now, do you understand that condition?
Yes,
Okay.
Your Honor.
Now, condition number 4 does not apply because that only applies in a DWI case. In your case, it's not a DWI case. Do you understand that?
Yes, I do.
Now, Mr. Commission, if you violate any one of these bond conditions, your bond may be revoked. And if your bond is revoked, basically a warrant will be issued for your arrest. You'll be placed in the Jefferson County Jail.
I just feel like there's been a lot of legalities that haven't stand in my best interest as far as my innocence. So for there to be further stipulations put on this juncture in my case, it's very obscene because it seems like in Beaumont, which has already made accusations against me, they're putting further stipulations on me, which could be at a detriment to my existence here. I'm a professional, a work professional that should have employment outside of this state, and the state of Texas, or I should say Beaumont, has charged me with an invalid account of or an accusation based on an allegation, and we haven't addressed that yet. Yet the severity with stipulations is being put in a profound way at the state of Texas on me, and it doesn't resonate with the truth of the man and the individual that I am in my innocence. That's why I have a problem with this. It's byline, it's further byline on top of an innocence. And I just feel it's wrong to be making this type of addressment or statement without knowing that I'm an innocent man who
Okay.
does not commit crimes, but yet we're in a city that has accusations and it puts people in jeopardy and is a detriment to their livelihood.
Okay, bond conditions are not punishment. These are
They
conditions.
can
No,
be,
listen,
though.
listen, listen,
They can.
listen. Okay,
I'll listen.
just listen.
Sorry.
Bond conditions are not punishment. These are conditions of your release. One of the court has an obligation when it set bond conditions. One consideration is the safety of the public. Another consideration is the safety of the individual. Okay. Bond conditions also can be based on the facts of the case. It could be based on criminal history. It can be based on the person's ability to make bond. It could be based on previous, bond forfeits. So the court can set conditions of bond pursuant to the statute. Okay, when a person is released, they're released. I think you have a bondsman.
Yes.
You have a bondsman. Okay, and so you have a bondsman.
But what I'm saying is this is stretched out for me. And it's so stretched out that it's preventing me from work opportunities outside of the state. So what it does is it puts me, if I was to like go out of the state for a job, which most of my employment is out of state, it keeps me, what it's doing is it's putting me, it's tying me down in this predicament. And
Okay, where in those bond conditions it says you cannot go out of state? Show me that.
You know what? It's not there, but what I am looking at is the fact that I'm an innocent man that's going into a
Okay, that's why you have a right to have a
Yeah.
trial by jury.
I hear
You have a right to have an attorney, and your attorney is gonna give you
Thank
all of the legal advice you have. You're gonna have your fair trial. The court is gonna treat you fairly.
Okay.
And so at this point, these are just bond conditions that the court has a right to set.
Thank you.
And
I understand, and I was only speaking from my own point of view, but thank you. I see your point on this. And
yeah, but
I'm ready to move forward. Thank
when we look at Texas Code of Criminal Procedure, Article 17.15 rules for fixing the amount of bail, the court can, fix whatever your bail amount based on that. But at the same time, the court can also set what we call bond conditions. Okay. And one of the main things of setting the bond conditions is, looking at the safety of the public. And not only that, but we have this order. This is a standard order. The court can have the ability under certain circumstances to modify orders.
The court has a lot of abilities. I notice as I make a realization through this or discovery through this, but how we say, yeah.
You see this?
Exactly.
This is
That's
a
my
law.
point. Yeah.
I mean,
Thank you.
So I'm not doing.
moving forward.
Yeah,
Appreciate
I'm
it.
not doing nothing that the law is not
Right.
giving me the authority to do. And
But
so
what
when you
I'm saying is, as lay people, we sometimes are not afforded the understanding of these processes. And then what's happening?
but that's why you were appointed
at the
at the
Jefferson level, it's going up to Texas because Texas took it on. And that concept, that legal concept, to me, is totally new as a Texan.
okay.
So now I'm with the program and I get what you're saying. Thank you, Your Honor.
But that's why you have an attorney.
Yeah.
Your attorney can give you all of the legal advice that you
Okay.
need and help you to
Yes.
understand your case and actually what you're
I
going
do
to.
understand. Thank
Okay.
you, Your Honor.
Okay, so at this time, your case, as I mentioned earlier, you qualify for an appointment of court-appointed attorney. Attorney Giles Cole will be appointed to represent you. Mr. Cole will be given information to contact you, and you will be given information to contact him. Our court coordinator is going to give you that information. Once you get that information from the court coordinator, you'll be free to go, and you have a blessed day.
Thank you.
Do you need it?
Thank
You are, just have a seat in that first chair by the wall.
Right. I'm gonna call you.
Next case is cause number 23 CCCR 1930. Case of Style of State of Texas versus Donald White Scheck-Snyder. Mr. Scheck-Snyder, your full name is Donald White Scheck-Snyder?
Yes, sir.
How you doing, Mr. Scheck-Snyder?
Fine, sir.
I'm doing fine, thanks for asking. Mr. Scheck-Snyder, would you please raise your right hand? Mr. Scheck-Snyder, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Scheck-Snyder, you may put your hand down. Now, Mr. Scheck-Snyder, I have two documents before me. First document that I have is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Or are these your initials on the line that state you'd like to apply for court-appointed attorney? Also, I have another document here. This document is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
Now, Mr. Scheck-Snyder, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Now, Mr. Scheck-Snyder, let me do this here. I'm gonna take this off. Ms. Herndon. Now, earlier you stated you wanted to waive your right to an attorney and represent yourself. Is that correct? You've talked to the prosecutor. You and the prosecutor have not been able, well, to reach an agreement, and you rejected the offer that the prosecutor has made. Is that correct?
Yes, sir.
Now, at this point, you could either still represent yourself, or you can, if you do not have enough money to hire an attorney, well, or you can hire an attorney, or if you do not have enough money to hire an attorney, you can request that an attorney be appointed to represent you.
Can I get one?
Okay. You filled out the affidavit? I don't have an affidavit. I didn't get an affidavit. You still have your clipboard back there? Octavia Herndon.
What do you need to fill out?
She needs to make her change on here first to that she's changing to see if she qualified for a court appointed, for a court appointed attorney. And let me see the affidavit. No. Give me the whole page, all three of them. Thanks. Oh, she was supposed to, well. Okay, let me do this here. I'm gonna get this back to her. You gotta fill, if you don't have it, then put zeros down here, zeros and all the blanks. If this does not apply, NA, okay? Just have a seat and we'll call you back up.
Smart.
waive your right to an attorney and to represent yourself.
Yes, Your Honor.
I also have another document here. This document is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding in the Trial. Do you recognize this document?
Yes, Your Honor.
And is this your signature on the line as titled defendant?
Yes, Your Honor.
Now, Mr. Torres, before you sign and initial these documents, did you read the documents?
Yes, Your Honor.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Torres, just have a seat and we'll have one of the prosecutors come out and talk to you about your case. Court is back in session at cause number 23 CCCR 1446. Case is filed with the state of Texas versus Octavia Herndon. Ms. Herndon, would you please raise your right hand? Ms. Herndon, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Herndon, you may put your hand down. Ms. Herndon, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document?
Yes, sir.
And is this your signature on the line as titled defendant?
Yes, sir.
Now, on this document, you have scratched through the initials that's on the line, say you want to waive your right to an attorney, and then you place your initials on the line stating that you would like to apply for court-appointed attorney. Is that correct?
Yes, sir.
I also have another document here that's titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes.
And is this your signature on page 2 on the above the line that's titled defendant signature?
Yes, sir.
Now, Ms. Herndon, before you sign and initial these documents, did you read the documents?
Yes, sir.
You understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Ms. Herndon, I read your answers. Based on the answers, you meet the eligibility requirements for the appointment of court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you. You will also be given information to contact him. And our court reporter will give you that information. Now, before she gives you that information, I need to give you some bond conditions. Ms. Mosley, could you hand these bond conditions to Ms. Herndon? Ms. Herndon. Let me see her. Okay, Ms. Herndon. The document that you have before you is titled Standard Bond Conditions in County Code at Law Number 2. You see that title? And I will go over this document, which in the document reads as follows. Following arrest and or accusation in County Code at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number one, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number two, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number three, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
What if contacted?
Don't contact them back.
No, I'm saying like as far as
You don't have to respond to it, do you?
no.
Okay, no communications. And do you understand that condition?
Yes.
And condition number four, the defendant who has been arrested, that doesn't apply to you because that only applies in the DWI case. And your case is not a DWI case. Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that? All right. So just have a seat in that first chair by the wall, and then when the court administrator or the court coordinator is ready for you, they'll call you up to the window. All right, you have a blessed day. Thank you.
Because it's when I'm looking at them, it's very confusing. So that you don't have any information. No, I don't. Because yours is really.
Jefferson County Court at number 2 is back in session. Court is in session. Cause number 23 CCCR 1384. Case is style of state of Texas versus Carbon Jade Rayleigh. Mr. Rayleigh, is that your full name? Mr. Rayleigh, would you please raise your right hand? Mr. Rayleigh, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Rayleigh, you may put your hand down. Mr. Rayleigh, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney, and another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, prior to signing and initiating these documents, first of all, do you recognize these documents?
Yes, sir.
And before you signed and initial these documents, did you read the documents?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Rayleigh, I also have before me a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Carbon Jade Rayleigh, on or about June 8th of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of burglary of a vehicle. Mr. Rayleigh, do you understand what you've been charged with?
Yes, sir.
And to discharge Mr. Rayleigh, how do you plead? Guilty, not guilty, or no contest?
Nothing, sir.
No contest? Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Rayleigh, I also have before me a document that is titled Misdemeanor Plea Admonishment, this is State's Exhibit Number 1. Do you recognize this document? Let me see on page 2 of this.
That's from today?
Yes.
And yes, sir.
And on page 3 of the same document, excuse me, on page 2 of the same document, there are initials in 2 locations. First location, the initial CR your initials are on a line next to a box that's checked no contingent, which means no contest. Did you place your initials on this document? The second set of initials is on a line below a paragraph that is titled Discovery Certification. And it is next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest.
Yes, sir.
Did you place your initials on this line as well?
Yes, sir.
On page 3 of this same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
On the next document that is titled Trial Court Certification of the Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Mr. Rayleigh, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Rayleigh. Are you a citizen of the United States?
Yes, sir.
State. I have before me State's Exhibit number 1. State, would you like to offer State's Exhibit number 1 into
Yes, sir.
evidence? Mr. Rayleigh, I have before me State's Exhibit number 1. State's Exhibit number 1 is the first document on the tablet that you recognize. It's also the same document that have your initials in the 2 locations that you previously identified, and your signature is on page 3. The state would like to use this document as evidence against you in your case. Is it all right for the state to use this document as evidence in your case?
Yeah, that's fine.
Okay, no objection. State's Exhibit number 1 will be admitted. Mr. Rayleigh, is there any evidence that you are currently mentally incompetent to stand trial? Okay. Mr. Rayleigh, let me do this here and take this off. All right. Now, Mr. Rayleigh, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
The agreement is to plead to the state's offer of 1 year deferred probation with a $400 fine, 50 hours community service, and the requirement that the defendant take a theft class.
Okay. Yeah. Okay. Okay, Mr. Rayleigh, the state is offering that you serve one year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $400 plus court costs of $277. You also be required to pay a probation fee of $60 a month, a urinalysis fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments will be $145 a month. Will you be able to pay the $145 each month?
Yeah.
You'll also be required to perform 50 hours of community service and attend a theft class and you will be required to adhere to the other standard terms and conditions of this probation. Now, Mr. Riley, do you understand the state's offer?
Yes, sir.
You think that the state's offer in your case is fair and just? And do you accept the state's offer? Mr. Riley, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Riley, do we need him to have a seat?
Does, my county Tom, take care of the, bond?
Did you talk to him about that?
No,
Okay,
I have 8 days, sir.
okay. So you saying to give, well, you talked to the prosecutor about that and see if,
No, his time doesn't do anything for probation.
There's
If he
not-
were to be revoked on probation, his time would count towards any jail sentence for that.
there's not, I'm talking about the bond.
The bond has not anything to do with the state. You'd have to pay your bond.
let's just say the fine.
The $400 bond?
What do you,
It does not count for fines either.
so what they're saying is, they not, in the plea bargain agreement, it wasn't agreed that your fine will be used as credit toward your fine and court costs.
Oh, so I got it.
So, I mean, you still have it, but that wasn't part of the negotiation
Yeah.
when you were
Yeah.
negotiating with the prosecutor.
Yeah, that's fine. I'll just get her, it'll be all right.
Okay. Just have a seat. When they're ready for you, they're gonna call your name.
Right here. or-
That's fine. Jefferson County Court at Law number 2 is in session and calls number M333958. Case is filed the state of Texas versus Kenneth Ray Clark. Mr. Clark, is that your full name? Mr. Clark, would you please raise your right hand? Mr. Clark, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Clark, you may put your hand down. How are you doing, Mr. Clark? I'm doing fine. Now, Mr. Clark, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Clark, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? And are these your initials on the line that state you like to waive your right to an attorney and represent yourself? I also have another document that's titled Waiver Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. Do you recognize this document? And is this your signature on the line that's titled defendant? Mr. Clark, before you sign in and issue these documents, did you read the documents? And Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Clark, I also have before me a document that is titled Misdemeanor Plea Admonishments. This document, well, let me do this here. I also have a document that's titled Misdemeanor Information. This document was filed by the Jefferson County District Attorney's Office. In this document, it alleges that you, Kenneth Ray Clark, on or about November 7th of 2022, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of attempt to elude police officer. Mr. Clark, do you understand what you've been charged with? And to this charge, Mr. Clark, how do you plead? Guilty, not guilty, no contest. Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Okay, now, Mr. Clark, before we go any further, you have a right to have a court reporter to type down or dictate everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter?
Wait.
You waive it? Okay. Now, Mr. Clark, I also have before me a document that is titled Misdemeanor Plea Admonishments, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's 2 sets of initials. One set of initials is on the line next to the box that's checked Nola Contendere. Do you recognize this document? And are these your initials on this line?
Yes, sir.
Did you place your initials on this line?
Yeah.
And on the second set of initials is below a paragraph that is titled Discovery Admonition or Admonishment. And it is next to a statement that reads as follows. I do not request discovery of evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty no contest. Did you place your initials on this line as well?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document, this document is titled Trial Court Certification of Defendant's Right of Appeal. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Clark, before you sign and initial all of these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Clark, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit 1. State, you like to offer State's 1?
Yes, Your Honor.
Mr. Clark,
Yes, sir.
the state is offering State's Exhibit 1 to be used against you in your case. Exhibit 1 is a document that you acknowledge on page 1 and page 2, your initials are in the 2 locations. And on page 3, your signature is above the line that's titled Defendant. The state would like to use this document as evidence against you in your case. Is it all right for the state to use this document as evidence in your case? Okay, no objection. State's Exhibit Number 1 will be admitted. Mr. Clark, is there any evidence that you are currently mentally incompetent to stand trial? Mr. Clark, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
The agreement is to include the state's offer of 6 months deferred probation with a $300 fine and 24 hours community service.
What's the court cost in this case? $352. Okay. Mr. Clark, the state is offering that you serve 6 months deferred adjudicated probation. During the 6 month probationary period, you'll be required to pay a fine of $300 plus court costs of $352. You also be required to pay a probation fee of $60 a month, or you're down to $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is the total amount that you'll be required to pay each month, is $223 a month. Will you be able to pay the $223 a month? Okay, now, Mr. Clark, let me do this here. Did he fill out a, does he have an affidavit on file? Mr. Clark, Ms. Mosby is handing you a document that is titled Affidavit of Indigence. Do you recognize that document?
It's just.
Yeah.
Okay, flip the page over, and on the back page, back side of that same page, there's a signature above the line that is titled Defender Signature. Is that your signature? Okay, now, Mr. Clark, is that information that is on the affidavit of indigence, is that information still current and correct?
Yeah.
Okay.
Maybe I got a little more take home pay.
Hmm?
I think maybe I got a little more take home pay, but.
I would say, so you still,
Understand what they gotta do with me paying to something like.
okay, I can explain it to you.
Yeah.
Before, now you stated that you couldn't pay that, and so the court has to, by law, the court has to determine whether or not you're indigent. Indigent means that you do not have the sufficient amount of money to be able to pay it, okay, because of your economic status. And so this information provides the court with all of that information. So that's why I went over this here. Other than that, we would have had to get you to fill out another one of these so that I could get this information, so that I can make the determination as whether or not you are indigent or not. Do you understand that?
Yeah.
All right. Now, what the court, let's see. The total on this, hold on a minute. Oh, yeah. Yeah. Okay, now, Mr. Clark. Let's see, that's, okay, now, Mr. Clark, the court, pursuant to Article 42.15 of Texas Code of Criminal Procedure, court will find that you're injured. And based on that finding of indigency, the court is going to convert the fine and court costs of, which is a total of $652. The court is going to convert that to 52 hours of community service. Okay? And the court is going to reduce your probation fee to the statutory minimum of $25. Okay? So that'll be 25. Okay, here we go. 25. Okay. So once the court converts the finding court costs to 52 hours of community service and reduce your probation fee from $60 a month to $25 a month, your total fee a month will be about $51. Okay? You be all right. Now,
Thank you, Judge.
yeah, okay, you're welcome. Now the 50 now, will you be able to pay the $51 a month?
Yes.
Okay, now
If I'm able to pay more, can
yeah, you can always pay more.
Huh?
You can pay more if you're able to pay more.
If
Yeah,
I'm
you,
able to pay more, can that reduce the amount of time on the community service?
you can talk to your probation officer about that.
Gotcha.
And I don't know about reduce it, but the fine and court costs, in essence, that can go toward the fine and court costs that has been converted to community service. Okay, now, so that'll be 52 hours of community service that's converted from the $652 of fine and court costs. And that will be added to the 24 hours of community service. So you'll have 76 hours of total of community service. Do you understand that? Now, so do you understand the state's offer? You think that the state's offer in your case is fair and just? And do you accept the state's offer? Okay, so Mr. Clark, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Clark, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure. You can talk to the attorney about a non-disclosure. Just have a seat, and then when the court administrator is ready for you, she's gonna ask you to come up to a window. Okay, you're welcome. David Torres. This is cause number 23 CCCR 1594. The case is styled the state of Texas versus David Torres Jr. Mr. Torres, is that your full name?
Yes, sir.
Okay, Mr. Torres, how are you doing? Mr. Torres, would you please raise your right hand? Mr. Torres, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Torres, you may put your hand down. Mr. Torres, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, David Torres Jr., on or about August 4th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Torres, you understand what you've been charged with? And to this charge, Mr. Torres, how do you plead guilty, not guilty, no contest?
No contrary. No contest.
Oh, and are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Mr. Torres, I also have before me a document that is titled Misdemeanor Plea Admonishments. Mr. Torres, do you recognize this document?
No, I don't actually.
Okay, let me see, show you on page 2. Did you place your initials in these locations on page 2 of this document?
Yes, sir.
Now, do you recognize this document? On page 2 of this document, there are a set of initials on a, next to a box that's checked no contendere. And are these your initials? At the bottom of this document, below the paragraph that is titled Discovery Admonishment, there are a set of initials next to a line that states, I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document is a signature above the line that's titled Defendant. Is this your signature?
Yes.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that document?
Yes.
And also I have before me the 2 documents that you acknowledged earlier. One document is titled Jefferson County Affidavit, Judge's Explanation of Rights of Defendants Without Attorney, and the waiver of counsel for purposes of entering a guilty plea or proceeding to trial. Now, before you sign all of these documents that I just showed you, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
And Mr. Torres, before we Mr. Torres, are you a citizen of the United States?
Yes, sir.
Now, Mr. Torres, as I mentioned earlier to the two other defendants in the previous cases, you have a right to have a court reporter to type or dictate everything that's been said, or you can waive or give up your right to have a court reporter. Do you waive or give up your right?
I wait.
Okay, you waive it? Fine. Now, Mr. Torres, state. I have before me State's Exhibit number 1. State, would you like to offer State's Exhibit number 1?
Yes, Your Honor.
Now, Mr. Torres, the state is offering State's Exhibit number 1 to be used as evidence against you in your case. State's Exhibit number 1 is the document that you acknowledged that had your initials on page 2 and your signature on page 3. The state would like to use this document as evidence against you in this case. Is it all right for the state to use this document as evidence against you in your case?
I thought that was just a big house that.
It is, but this is also State's Exhibit number 1. So the state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case?
Yes, Your Honor.
Okay, no objection. State's exhibit number 1 will be admitted. Mr. Torres, is there any evidence that you're currently mentally incompetent to stand trial?
I don't know yet. Talk to Spindle talk about that. I don't know.
Okay, you understand what's going on?
I think so.
Okay, well, I'm just asking you a question. Do you understand that you currently in a court of law?
Yes, Your Honor.
You understand that you entered a plea of no contest to the charge of criminal trespass?
For probation, yes, sir.
Right, and we're gonna get to that. And so you understand that when you had a right to have an attorney, however you waived or gave up your right to have an attorney, you decided to represent yourself, knowing that there was dangers and disadvantages of self-representation. Is that correct?
Yes, Your Honor.
Okay, so now, so do you still want to go forward in your case?
Meaning, do you want to go forward with the plea?
Honestly, I'm tired. I don't even know. I think I just want to get a court appointed lawyer before I make.
Okay, well, that's good. So we're gonna,
I'm too tired to even think.
okay, well, that's fine. That's what I needed to know.
No.
And so what the court is gonna do, the court is gonna reject this plea bargain agreement. And at this time, you said you want a court appointed attorney, we're gonna have you give you an opportunity to fill out an affidavit of indigence. And once you fill out that affidavit of indigence, then we'll ask you to come back up and okay.
Mhm.
All right, just have a seat. I'm gonna send this back to you.
That's it, just fill all this out. Finish this.
Yeah, it's he already filled it out.
No, not the.
Oh, you need to fill all of that out. Oh, yeah.
That's part, correct?
The first page. No, that's not Clark. His name is Torres.
Oh,
David Torres Jr.
wow.
He never filled one out. Okay.